bill to the House.
Jacinda Ardern.
Thank you, Mr. Speaker. Please had an opportunity to speak on the Privacy and Information Sharing Bill, which in and of itself may not seem a highly contentious piece of work, but taken in conjunction with some of the serious issues of the day that this House and our communities are currently facing is extremely relevant. But I think, as my colleague Charles Chauvel has already pointed out, I think it's really important that we delve a little more deeply into the problem identification in order to really establish whether or not this bill is going to resolve issues that we currently face. And in that sense, I would still like to hear more from government members in that regard, because these are tricky areas. We are trying to ultimately ensure that we continue to strike that incredibly important balance when it comes to privacy issues, and that's ultimately preserving the rights of the individual to privacy, whilst at the same time ensuring that where it is appropriate that information be shared for their best interest and their protection, for example, that is the case. So, and making sure we have checks and balances in there at the same time. Now, the most obvious example of that is when it comes to the issue of child welfare. I would have liked to have heard more from government members about where the system is currently falling down, so that we could truly test whether or not these new measures will remedy that. In that absence of that, I'd like to delve into them a little more, perhaps as an indication to the Select Committee as to where we might like to head. As my colleague has already pointed out, this bill is as a consequence of a Law Commission review, and we are still concerned that parts of the recommendations from the Law Commission have been carved off, and that we are dealing with this in a somewhat a piecemeal way, particularly given we are still conducting a general process of consultation around child welfare, for instance. So in a way, this is a very piecemeal way to address the issue, but nonetheless, one of the first things that the bill begins to do is to look at the way that exceptions to information being shared and privacy principles have been used in the past. And I was recently at a seminar where a lawyer specialising in public law pointed out that we may be remedying a case of misuse of the Privacy Act in its current form, and that risk-averse, in some cases, public servants may, because of the lack of clarity around the Privacy Act, have acted in a risk-averse way, not necessarily in line with the expectations of the Privacy Act as it currently stands. In fact, I believe the Law Commission even created an acronym to refer to when this occurs. That is unfortunate that we're having to amend, therefore, our legislation to deal with practice rather than the intent of the law itself. But if it is being misused and not used appropriately, then we cannot ignore that as a parliament. And one of the exceptions that currently exists within the Privacy Act, which one would have thought could have been used in some of the cases we've seen more recently involving high-profile child abuse cases, is that information is able to be shared if there's a serious threat to public health or safety or the life or health of an individual. Imminent threat. Now, that is being replaced due to, in this bill, due to a view that imminent didn't give enough clarity to the users as to what was intended. I would contend that any descriptors in this way do have an element of subjectiveness attached to them, and therefore I'd really implore the Select Committee to make sure that we test some of these thresholds to ensure we think there is enough clarity around them, and even test whether or not guidance will be required from the Privacy Commissioner to ensure that we don't have the same situation arrive that we currently have with the Privacy Act as it stands. Secondly, this bill will insert a new provision to allow for information sharing agreements. Now, the impact assessment goes into the detail of the options that were available to the Ministry when considering such a new mechanism, and I think has taken the option which has more checks and balances attached to it. But one thing I want to test is how would this operate in an everyday situation, for instance, in an area of child welfare, given that this is the area the government has flagged that this piece of legislation is necessary. The bill, as I understand it, sets out that one of the signatories to an agreement would have to be a government department and could then be with another, for instance, contracted NGO, for instance, who might be dealing in the area of child welfare. Now, my question is, we have a number of smaller organisations in our communities who are contracted by SIFs to deal in the area of child welfare and well-being. Is it realistic to expect that these kinds of arrangements will be agreed to between SIFs and one of these smaller agencies, given the process that must be undertaken? For instance, it states in the introduction to the bill that approval of information sharing agreements must be done by order in council, and that approved information sharing agreements, of course, will then need to go in through consultation with the Privacy Commissioner and other interested parties. Now, of course, I would expect these kinds of checks and balances to be in place, but what are the expectations for the kinds of organisations who would enter into these agreements, and do we think it is realistic that some of these community organisations would go to this extent? What kind of timelines do we expect for each of these individual arrangements to take? Will there be any kind of templated agreement that the Privacy Commissioner is likely to construct? These are the kinds of questions I'd like to see discussed at Select Committee. Otherwise, we may in fact not see a real significant change in the way that some of our government departments are working with agencies in this area, unless we really test that threshold and those expectations. I want to come back briefly, if I may, though, to the origins of this bill from the perspective of the government. Obviously, this piece of work was instigated earlier than some of the reports which have since endorsed its work. For instance, the report recently released by Mel Smith into the terrible case of a child being tortured by her parents, which identified that multiple agencies were involved in that child's case, but information was not adequately shared. I'd contend that there are other layers that exist within a situation like that go beyond information sharing, and we need to ensure that we address those if this bill is really to have the intended effect. For instance, once information is shared, we often see in a number of cases a lack of clear pathways as to who is ultimately accountable to that individual family or that child. Does the accountability sit with a SIF's social worker? Is it a situation for police intervention? To what degree has a school been involved? And I've seen many cases before where a lack of clarity around who is accountable has in fact led to the ball being dropped rather than solely the issue of whether information is adequately being shared. That is an issue probably primarily for the Minister of Social Development to address, but I would contend that in and of itself, suggestions like these will not work unless we resolve some of those key issues. Secondly, all of this will be completely redundant unless we ensure that the agencies who are dealing with these difficult cases are well resourced, and that's something I think we also need to flag. One final point I'd like to raise is the Green Paper talks about information sharing as well, but goes much further than this bill currently intends to go, and I'd like some clarity from the government as to whether or not they may go any further in future. The Green Paper states the government could review the current provisions in legislation to ensure professionals at the front line, such as teachers, social workers, GPs, nurses, psychologists, police officers and therapists, are able to freely share information about the children they work with for the purpose of accurately assessing their needs of the child and their family and whānau. That goes beyond the realms of this bill, and it would be interesting to hear from the government what their intentions are once the green paper submissions have all been received and the white paper, which the Minister assures me has not yet been written, comes out. Are we going to go beyond the scope of what has been recommended in this bill? I look forward to there being further debate at Select Committee. We continue to have a few concerns around the way that this bill has come to the House and the areas it covers, but I'm sure those will be explored further on.
I call Jan Logie.
Thank you, Mr.